Mr. Vijayendran, thank you for sharing with us on the first segment. Now we'll be moving on to the next segment. With these challenges and the current solutions in place, we think that it's apposite for us now consider the next step, which is moving into the future. So, Chuman?
Yeah, so I think the first question that we will be asking for this segment is that as you move into the new normal, what do you anticipate to be challenges and tensions in the law with regards to public law challenges or possible other tensions as well?
Yes, I think that's a good question. There are obviously a few areas that one could dissect in respect of this. I think in times of pandemics or other types of crisis, there are tensions that you have to navigate between human rights on the one hand and trying to combat a pandemic on the other before it becomes a bigger problem. And so there is as it were, a bit of a social contract. There's a trade-off. The members of the public agree to, say, more invasions of privacy, intrusions of privacy, giving up some of that, giving up some of your rights, because they believe that we need a community response. And so hence, the need for us to stand together, to try and combat this health issue and to comply with the laws of the land. What is important is that I think when the crisis improves, when the crisis becomes a thing of history, that these laws would have to be revisited to consider their appropriateness, because the balance needs to be calibrated or recalibrated so that it doesn't become disproportionate to a normal situation. And so we can't see a temporal effect on human rights become a permanent effect on human rights. And I think this is the tension that's not just unique to Singapore, it's unique to other societies as well. I've certainly been very impressed by the response of our Singapore government. It's been characteristically decisive and efficient, as Prof. Kevin Tan has mentioned in an article. And it's very true that the speed at which a number of these emergency legislations have been rolled out have given us a cutting edge and have demonstrated the ability of our policymakers to think 10 steps ahead. What's next, and not be flat-footed, which I'm afraid sadly is the experience of some other jurisdictions. But as I was saying, I think when all this is over, and even as the crisis improves, one needs to ask yourself whether certain laws are no longer proportionate and may need to be revisited. And so I think therein lies the delicate tension between the two. The other issue that one needs to consider is the access to justice issue. And here I had made the point earlier that certainly from the society's point of view, the pro bono arm's point of view, as well as the society's leaders, we need to discern who are the new vulnerable. And once you discern the question of vulnerability by reference to access to justice, then we need to have a response. And I'm not going to pretend that the lawyers have all the answers. We don't. It has to be a multifaceted response. And so when you have access to justice issues, say with a certain community, migrant worker and so on, it needs to be a combination of legislation, the do-gooders who step forward with their altruistic energy to serve that community, schemes such as the one that Law Society is considering in terms of migrant worker clinic, the efforts of the wonderful NGOs that are also coming alongside on this. But it's got to be this kind of collaborative, many helping hands approach to try and help access to justice or ensure that there are no barriers or obstacles to access to justice which make it worse than what it was. And so that is where we have to be very, very sharp, very vigilant, about the matter. So I cite those two examples, and I could also share more, but those are two examples to bear in mind about some of the tensions that will need to be navigated and the issues to be considered.
Thank you, Mr. Vijayendran, for that. I think that's something that is definitely very important for us to take note as we move into this new normal as well. But I think for the next question, we'll be talking about something that you actually mentioned just now. You talked about the primary, secondary, and tertiary victims of the crisis so far. And this question focuses on the secondary, our businesses and the economy. And I think for this question, we will focus on the legal profession. So I think a few months back, McKinsey published an article on the implications of COVID-19 for the law firms around the world. And they mentioned that it's expected that litigation and restructuring practice areas will do well, while other transactional practices will suffer. I think in your opinion, how do you think COVID-19 has affected the businesses for law firms? And do you think there will be a permanent shift in the nature of work that lawyers will do in the future?
Thank you very much for asking that question, Chunman. And I think, I mean, this is a topic that is close to my heart, close to the hearts of the bar leaders. And our hearts indeed go out to what is happening in the profession. We've never had the challenges that we're seeing now in the history of the legal profession. We've never seen the like. In all my years on council and all my years as president, this is an unprecedented crisis in which there is no playbook to refer to. There are no formulas, there's no precedent, there's no magic bullet. And so we have our work cut out for us. But let me sketch the diagnostic aspects first. And I need to go back to my survey that I referred to earlier. So what did we ascertain from the survey about the impact on law firms' economic health? That was a critical aspect of our own assessment for the purposes of financial stimulus packages, strategic intervention measures, which are two prongs of a five-pronged strategy that the Law Society is rolling out. So what did we ascertain? That the swift spread of COVID-19 caught most businesses by surprise, and the downstream effects were acutely felt by the legal service providers. And that kind of makes sense because we are service providers at the end of the day. If there are less deals in the market, there's less demand for legal services, therefore there's less work for lawyers, and therefore there's less revenue, and so on. And so in that sense, that becomes an economic challenge in its own right. And I think a lot of corporate lawyers, in particular transactional lawyers, real estate lawyers would have felt this in terms of the impact of COVID on their work, on their practice. And so essentially when we went into circuit breaker and the government's circuit breaker measures shuttered the work premises of non-essential businesses and restricted movements of residents in Singapore, it put the economy in semi-hibernation, or what some have also described as semi-lockdown. I think that's the reality of what happened. So I've already spoken and shared about work from home, but some data points about the impact. 70% of the respondents in our survey reported a decreased workload. 20% of the respondents reported no change. 10% indicated an increase. So that was a fascinating data point. So we drill deeper into that. And this is what we found. In those who reported an increased workload, this was the further breakdown. 42% said it was due to a combination of new and existing matters, 22% new matters, 18% existing matters due to COVID-19, and then 18% existing matters. So the highest number is it's a combination of new and existing matters. Some of the existing matters, again, from the point of view of life cycle of a project, you could understand because the projects would have started in 2019, 2018, they're coming to fruition. Or if you're doing a case and you're coming up for trial now, or you're gearing up for trial in the second half of the year, then you're still in business, you're still doing work, and so you're relying on the existing pipeline. But the question is how much new work will come your way. And so what we found was that where was the new work coming from? The 5 areas that we discerned that there was the greatest increase in workload. First, family law, top 19%. It's about 1/5. Then about equally close to that, civil and commercial litigation. Then bankruptcy and insolvency law, employment law, and landlord and tenant law in that sequence. And so in that sense, the spike in family law is unsurprising. I think we've read of the phenomena of corona divorces in East Asia, Japan, China, sadly, right? When you shutter people in, and they have to live in close quarters with each other, familiarity breeds contempt. And in some cases, tensions are high, and sadly, relationships are on the rocks. And studies have shown that. And, so I think that's just a temporary spike. I don't think it's a permanent change in terms of the ecosystem. Civil and commercial disputes were on the rise, that's for sure. So for firms that have, full service practice areas, the disputes practices were sustaining the other cylinders that were down. And so in that sense, disputes work was on rise. And what we, of course, need to also consider as part of overall analysis of that is whether the clients still had the same fee appetite. And there the answer is no, not across the board. Clients were not prepared to pay the same type of fees in a number of cases as they would in a pre-COVID situation. And so that in turn was a direct cause of their own troubled or distressed situations. In some cases, it affected cash flow or their own liquidity, and then, of course, they might have been facing insolvency issues of their own. And so, what we saw, and this is anecdotal, is a greater requests for fixed fee payments. And while the disputes work were up, I think the will and the appetite to take it all the way was affected. So more people wanted to see solutions involving mediation, negotiation, resolving it, and trying to take a lesser sum or a sum that you would receive by way of installments, or have cash. Cash is king in this type of environment, right? So I think a lot more people were actually trying to find those types of dispute resolution options, and we can talk a little bit about that later if time permits. The insolvency and restructuring work was up, that's for sure, and I think it's that side of the cycle. And so people who practiced in personal bankruptcy, corporate insolvency, certainly saw a boom time. Employment law was also up, and I think this one is a point I've touched on, and landlord and tenant law. And some of these are also the subject of special and emergency legislation. So that's the snapshot of what we saw. But now, question of what would the potential blue ocean areas be? So here, you can gather different thought leaders and top leaders of the profession, and you can listen to the pundits, and probably each one has some wisdom to offer, and so this is mine. My own view is that some of the areas that could result in potential growth would be, and some of this we've already seen from the survey, which is, for instance, the employment law aspects, insolvency and restructuring. I think construction disputes will continue to be up. Regulatory compliance will be important going forward. And I think lawyers who advise in that space will see a lot more volume. And I think that will be also a growth area for potential lawyers to specialize in, and for potential law students to consider building some niche expertise in. Healthcare law, I think, will be important, will be critically important. And we haven't traversed some of the really interesting questions that may give rise to novel decisions in our court of law. For example, if somebody is a super spreader of the virus and spreads it in disregard for healthcare laws, yes, you can punish him, but how do you analyze the duty of care? Can there be other claims brought against him if somebody suffers serious illness, worse still if there's a fatality and so on? And on first principles, I think the answer must be yes. But again, these are novel situations, and there may be other unusual situations that may need to be considered. But I think healthcare law will be an area of growth. Then, of course, an area that is a bit of a no-brainer once you hear this, e-commerce law. A lot of us are doing a lot more online purchases, basically making online service requests. And there's a lot more e-commerce traffic. So the likes of, Amazon and, other big players, will certainly, see a lot more traffic. Your online groceries and all go up. And so here, I think you will see quite a bit of growth. It may not be growth across the front end or perhaps even the dispute resolution aspects compared to, say, the dispute side. The dispute side, I think, may be minimal. And the transactions involved are very small, so you wouldn't litigate over, these sums as a general rule. But you may see a lot more work at the front end. And then the last area would be more contractual disputes, particularly force majeure, frustration, and of course other novel sort of offerings to deal with the problem that the government may have by way of their own legislation. So I think those are some areas to watch in my view, and potential areas of growth which are a bit more systemic. But I will also say that and this is another prong in the 5-prong strategy that I mentioned, we are test trialing innovations as well. And I'll mention one of them later, if we get a chance to talk about mediation. But in terms of innovation, we are asking the profession to share with us what are some of their bugbears. What are some of the pain points in the current legislation that is affecting, stymieing innovation? And how can we make the case to the powers that be to consider policy change and legislative change to allow for some of this innovation? Maybe it will be a regulatory sandbox, maybe some of it is going to be pilot, but if not now, then when? And I think we have to really cater for the maximum creativity, innovation at this time. So I think one area that I'm a great fan of, and I'm not the only one on this, my predecessor, Shenyi, is also a great believer in this, is multidisciplinary practices. I prefer to think about it as bidisciplinary practices. In other words, say law and accountancy, law and social work, law and counseling. Those could be some examples, and many others as well, where you can have a teaming up of professionals to offer a one-stop shop and a solution to the client's problem in seamless fashion. Where basically you look at it in the round holistically and you solve the client's problem. And actually, there would probably be a lot more savings, cost-wise, time-wise, and in terms of something that really does the job optimally with that type of solution. That's one area that we are asking the profession in a further survey, which is underway as we speak, to share their views on those types of structures, as well as other alternative legal structures as well. So those are, I think, some areas. The other area which I have mooted publicly and on many other settings, so including with the government, is combining tech with travel. What do I mean by that? Yes, we can't travel now, but we can use tech to travel. And so effectively, you can promote yourself by using webinars, by using various tech offerings to showcase your expertise or your specialization at a global level, right? And so you can be transmitted to the other side of the globe by way of tech. And so if we do this intelligently, if we do this in a way that's respectful of the lie of the land, obviously, we need to be sensitized so that we're not transgressing local laws and doing this in a way that, affects, the livelihood of others. But, we can do this intelligently and showcase it. I mean, I'll give you an example. Supposing a lawyer and accountant get onto doing a webinar together, and they cover a certain topic, whether it is restructuring or whether it is, something involving risk management or governance, and you do it as a joint offering, and we're not calling it the law of a country X. We're not speaking to that, but what we're doing is we're offering a consulting solution. We're offering a business solution, right? And then at the end of it, you leave your contact details. And so if people are interested, they know how to reach you. They know how to email you. Then you can actually have a new market there. You can have a new client there. You can have new business there. Now the sky's the limit. And that's why I chose this background as well, to try and help us visualize that, we need to think beyond our existing space and use this opportunity, to really build our practice in ways that we've never seen. Now, obviously, we need help. We need to partner with the government. I think that this is an exciting moment. What if we re-envision Singapore to become an e-hub? What if we find a way to seamlessly connect e-mediation with e-arbitration with e-litigation? And this becomes a cutting-edge IT solution. And even if you have got a problem with no ostensible nexus to Singapore, and of course, SICC, already hears disputes, offshore disputes, and the parameters to that. But if they are drawn not just to the high tech factor, but they are drawn to the high trust factor, that here we have a world-class bench, we have world-class arbitrators, world-class mediators, and we have a world-class bar. And here we are to serve your needs. I think the sky's the limit.
Thank you very much, Mr. Vijayendran, for your sharing on that point. Actually, you mentioned this twice. So the next thing, I think what's coming up. We're going to talk about mediation and alternative dispute resolution. So general thrust of lawyering, of course, is litigation, and I'm heartened to hear that you said that people are exploring other methods. People probably normally assume in a hard time like this, people are lawyering up, going to war when cash reserves run dry. And of course, temporary relief granted by the COVID-19 Temporary Measures Act is not permanent. So as in your position as Law Society's president, what do you think businesses should do in terms of embracing alternative disputes? What do you have to say to businesses who think that such methods are just litigation-like?
Yes, I think that's a very, very perceptive question. And it's also an insightful question, which I think merits, a complete response, Thomas. So I think it's something I'll speak to. I think it's very much a case of considering the needs of the client as first and foremost. We're a service provider, right? What does the client want? I mean, in some exceptional cases, they may want to test a point of law because it may have a precedent effect for other types of cases that other types of transactions that involve in, say, a particular contract and clause. There are matters that rightly go forward. But for many business organizations, many businessmen, businesswomen, they are looking for a solution that is fast, that is cheap, and that is able to bring certainty and closure to the matter. And so for a number of them, they're not prepared to wait. And, of course, our courts are super efficient, and, you can have a dispute heard from start to finish in 18 months. But, in many cases, in other jurisdictions, for example, which, we know that there are problems in terms of delay and administration of justice, I think the business folk get frustrated. And I think if we look at it from the lens of our clients, the question is, and maybe sometimes it's also good for us to put on those shoes. And I think for those of us that have been clients in a case, maybe then you understand things a little better. But when you look at it from that lens, then I think dispute resolution options, I think, readily lend themselves for consideration. So negotiation, mediation, neutral evaluation, conciliation. These are all various types of dispute, sort of resolution methods that are alternative to formal adjudication processes like litigation and arbitration. And mediation, as we know from the big boom that has occurred over the last decades or so, Singapore has obviously been ahead of the curve, but with the Singapore Convention on Mediation and also our Singapore Mediation International Center, which complements the Singapore Mediation Center, we are now very, very well positioned in terms of thought leadership, in terms of having mediators with pedigree, in terms of having the infrastructure. And I think that's one of the points that I would say this country can offer, because we can give you the entire ecosystem. It's not just about an office per se, but it's the entire ecosystem that supports it. We have legislation such as the Mediation Act, that gives mediation agreements bite, and enables you to stay, if somebody wants to litigate instead of mediate in a multi-tier dispute resolution clause setting. So, all these tools and levers have promoted a very strong world-class brand of mediation. And I think that, certainly for every case, consideration must be had. And, that's undergirded even by ethical considerations for lawyers. Regard must be had to a cost-benefit evaluation. Regard must be had to alternative dispute resolution. And where appropriate, you would explore it and see whether you can find a solution. Now, superficially, it looks like as though, well, I can't make so much money because if I take a case for trial, that's when I'll earn a lot more per day, and the preparation and so on. Yes, I understand that point from an economic impact point of view. But human nature being human nature, we know that some cases will go forward. And, people will be unreasonable, people will be greedy, people will not accept wisdom. Human nature is such. And so I think Abraham Lincoln had a famous quote on this too. So, in a sense, we don't have to worry. There will still be cases in the pipeline. It's going to go the whole hog. But for a number of them, you are actually doing your client justice, and you are acting in their interests in finding that solution, which is one that they can own. And mediation in particular, and I single that alternative dispute resolution rate, it's actually no longer alternative dispute resolution in many ways. It's actually one of the primary modes of dispute resolution in my view by now. But it enables the parties to own the solution. It enables parties and lawyers to collaborate in a problem-solving way, in a way in which you're not limited to what is pleaded, the reliefs that you would get as a matter of law, but to put on a creative thinking cap to find solutions. In an Asian culture, it allows you to give face, to the other party. And, in that sense, there are many, many pluses for it. Now, I had alluded in one of my earlier answers to something I wanted to say about online mediation. And I was alluding to that because that is part and parcel of the strategy that we have in terms of trying to test trial innovations in this period of COVID-19. So Law Society has a Law Society mediation scheme, and it's a way for us to help our lawyers to start on the journey of mediation. Some of them may not have the full credentials to be on the panel for Singapore Mediation Center, and they're on a journey. But through that way, we basically also resolve disputes. It's done through referrals, it's done sometimes through contracts. We are in the midst of trying to insert a clause into the lawsuit conditions of sale for real estate, to also have parties consider mediation, LSMS, our Law Society Mediation Scheme. So one of the innovations that we did in this period was to test trial online mediation. And we found that this is such an interesting facet. Of course, some of the senior mediators need to be trained. I myself mediated on a few occasions as a mediator in an online setting, and we were not worse for the wear. You can do your breakout rooms, you can have your joint sessions. Yes, you miss out on some of the nuances about body language and reading the person that I mentioned earlier. Yes, but this is the pragmatic, realistic solution. And it's pragmatic and realistic when, for instance, you've got two parties who are overseas who can't fly in, or one party is overseas, and so you kind of have an asymmetry. But these are actually very realistic, sort of options that are considered, and they can work. They can work. So you can. It may not be the best, but you can still demonstrate EQ. You can still facilitate and be people sensitized. You can still try to conciliate as best you can. I've done a conciliation online as well, where at the end of it, parties ask for forgiveness. So you can actually do that. Is it the best as face-to-face? I think let's not kid ourselves. But it is the pragmatic alternative, and it seems to work. Now, hot off the press, China is on to something even greater. I've talked about dispute resolution, but if you read Susskind's thought leadership in his books, you will know that he also refers to something called dispute prevention. Dispute prevention, and particularly in the context of infrastructure contracts, we already have some inroads into that in Singapore, but China has taken this to a whole new level. Tomorrow we will have the inauguration of a new organization that has been set up by China called the International Commercial Dispute Prevention and Settlement Organization, ICD PASO. And the Law Society of Singapore is very privileged because we are on this organization's founding member role, and we are actually very, very privileged to be seated on the council for this. And so what does this entail? It entails that basically early on in a project, and you can imagine for infrastructure projects, construction contracts and the like, a problem happens. You don't want to go and litigate when the project is still 1/3 completed, half completed, still underway, because you win the case, yeah, but you spoil the relationship. You need to find an efficient solution where you can have technical consultants solving that problem and saying, this is the answer, now get back to work, get back to business. And so this is what I would call dispute prevention mechanisms. And if we can weave them into existing contracts, that could also be another avenue for lawyers to find value in their own role and to be able to socialize that value with business people and to essentially troubleshoot some of these aspects. So that I think is something that is worth considering, as a way of the future as well, dispute prevention. But I'll leave you one other idea which I think is hot off the press. I'm still processing the ramifications of this. One of the big topics of our time is bullying and harassment, and including, very sadly, also like bullying and harassment, very, very sad sexual harassment cases as well. So could lawyers perform the role of some type of external ombudsman in some of the organizations? We are trained legally and with some skills in terms of baseline counseling, in terms of EQ, reading people, and listening skills, and also knowing what are the potential resources that can be called upon when it's serious enough to merit a complaint and so on. There may be a potential growth, and I say this more as an idea. I've not analyzed it. I've not stress tested this idea, but I think there's potential for some organizations to say, I create this channel, and it's a grievance channel, and it's a hotline that goes to an externally appointed lawyer as the ombudsman of the organization. So again, this is something that involves dispute resolution, dispute prevention, and conciliation as well, which could be an avenue that may also grow in the future, but that's an idea.
Thank you very much, Mr. Vijayendran. In fact, I think I just had a thought that I think my prof is going to kill me, because the actual term is appropriate dispute resolution. I think that's the new terminology they've used nowadays, and that really speaks to what you said about doing justice as between parties, and not just a pursuit of what is the point of the law. And so I just want to bring you into what is the final question, and this is something that's close to Chuman and I as students. So the COVID-19 situation has changed the experience of legal education for law students, as well as the training for new trainees and those taking Part A and Part B exams. So in light of this, how do you think we should move forward in legal education to ensure the same rigor and efficacy of education and training for the next generation of lawyers and beyond?
So I think that's a very relevant question for both of you. And again, there are probably much wiser heads than mine, to be honest, who can speak to this issue, many of whom are from the university that you are at, and some of our outstanding thought leaders of the day, including our law ministers and Chief Justice. But here's my own, sort of offering on this question. Well, necessity is the mother of invention. So, because of the nature of COVID and the restrictions that are imposed by public health, and of course those are easing up numbers-wise. But I think online pedagogy is here to stay, and it's probably going to be very much part and parcel of the nature of legal education going forward. Of course, it might be very much hybrid. It might be interspersed with physical lectures and so on, but it is definitely a mode that I think both could limit but could also enhance legal education. What do I mean by that? Limit because there's nothing like being like, even now I would much rather be in the studio with both of you, and when I see you looking at your watch, I would know I'm talking too much, but I mean, I'm just joking there. But the limitation of the experience that I've already touched on. But and I think we all want to ask questions. And sometimes some lecturers also want to be able to facilitate that. The nature of some of these Zoom classes or even online learning modalities is everyone, I think, is silent. You're listening to that one person who's speaking. Then sometimes you got to wait until they finish before you chime in. So it creates a dynamic of its own. And some, I think I've noticed from my own experience chairing meetings as well, that, people tend to listen more to the leader. People tend to listen more to the chair. And so does that lead to its own set of interesting dynamics? Yes. And I think we need to overcompensate for that. Now, that's limitation. But what about the enhancement? Right now, one of the biggest advantages we are seeing with the use of webinars is that we can stream in people from any part of the globe. And it's an amazing experience. I was at a Law Asia Council meeting yesterday as a counselor representing Law Society of Singapore. And here are all these law leaders, bar leaders from USA and Australia and different parts of Asia, India and so on. And we don't have to fly in to a particular locale, we can be streamed in. So the potential for that in terms of education, where you can introduce guest lectures, where you can introduce maybe practitioners at a certain juncture as well. Say if you're lecturing in trusts, and then maybe like say the last 15 minutes now, let's hear some of the practitioners on this point, and then you assemble them. So there is both a plus and a minus, and it's how you can harness it. Are all law lecturers going to warm up to this? No, I mean, I think we got to be realistic, just as in the profession, some have taken longer, but, and some would have some natural inertia. I think all of that is understandable. But I think this is one big change. Now, at the same time, and I started off by saying that this COVID crisis is unprecedented. And so what you are doing also, you think about it, if COVID didn't exist, you wouldn't be doing what you're doing, COVID, right? So, and I mean, credit to the team, Anders and yourselves and others, and I'm very glad that the media has also profiled this wonderful initiative, in which you've actually stepped out larger than life to impact the community by lining up, speakers to share. So I think because of the uncertainties of the future environment, we need to have more thought leadership on where are the potential areas of growth, what is society going to look like, what is the world going to look like, what is cross-border trade going to look like, will there be more e-offerings? And so when we realize that fundamentally we are a service provider and that we are, as a profession, trying to enable, facilitate, provide the access to justice, give an opinion to ensure, that something complies with the law, and of course analyze, essentially it's responding to societal needs. And so we have to have the futurists speak to the issue and to try and discern from that, where are the areas that, for elective purposes, for, selection of causes to specialize in, that our law students need to be looking into. I mean, the fundamentals, the basic subjects, those are foundational. Those will never change. You need to have, all those tools of the trade. If you don't have those tools of trade, you don't ace your subjects, you don't do well in them, it will also affect your ability to practice as a lawyer. There's no doubt about that, foundational skills, legal research, methods, drafting, different things, as well as, various core subjects. But for the electives and what to specialize in, I think rather than carrying on with the same old, assuming that the market hasn't moved for the last 200 years, I think we need to be realistic. We need to be pragmatic. We need to be, commercially sensitized. Subjects like conflict of laws, comparative law, those are going to be increasingly important in my view, and more so. And so I think the need to be able to understand different legal systems, civil law, common law systems, to be able to speak the language to another lawyer from another jurisdiction according to how they understand the law. those are going to be real value propositions for the law graduates of the future. And I would say two more things as more of parting points. And the first of it is, I think, in as much as I know some are undecided what to get into, should you be going into corporate, should you be going into litigation? Internships, of course, help. I know internships are affected, and we are encouraging the profession to offer winter internships. I've written a piece on that, and to continue to offer even online internships, and those are pragmatic ways to deal with the issue, and those also help students to try and understand a bit more about practice. We may need to look at externships as well, different things that could be helpful. And the whole point is to try and understand, I think the role of internships, one of the greatest value proposition, is also to eliminate what are the options you do not wish to consider, once you step into practice. So it could help you in the process of elimination, just as it could help you to also know where the natural magnet is to draw you to that particular field. It could serve both purposes. And so I think the internships play a valuable role. We must continue to encourage that. We will do whatever we can as a profession to encourage that as well. But the point that I want to leave with you, that first point, before I end, I've got one final point, is to get to start to think as specialists as well, to the extent that you have a penchant or a passion for a particular area. If you know you are gifted, that you've done particularly well in a particular core subject, or you have an interest in a particular domain or industry, start to look at how you can pick up a greater specialization in that area, whether it's to pursue a master's after your LLB, whether it's to choose the right electives, whether it's to pick up industry expertise. I have colleagues, even in my firm, who started off in the industry and who came to law later and who are masters of that industry. When I bring them into meetings, they connect intuitively with the client. There's no need to explain the terminology. They get it, and they don't have to spend a lot of time or even incur costs for that. And so there's a huge plus for those of you who are sure of what you want to do. And once you're sure, go for it like an arrow. The second point I want to leave with you is that I know these are very discouraging times. The lingering news about oversupply of lawyers, practice trainees not being retained in some cases, concerns about finding a job. Law Society is trying to do what we can. I met a group of newly called lawyers who were looking for a job. We're trying to do what we can as well to help, even though technically they're not members. But I think, as I've shared before, we owe a duty, not just to the lawyers who've gone before us, the lawyers who are with us, but also to the lawyers who will come after us. And we have to think generationally. That's something I try to encourage the society to embrace. But for your generation, for your group of law students, I would encourage you, don't look at this through a gloomy lens or a despondent lens, or think that you must give up some things that could enrich your university life. I had a very rich university education, and I was very active as a hostelite and as a student as well, as a law student as well. So I would encourage you to embrace the entire education, and even if it means doing pro bono, I wouldn't sacrifice pro bono as well, merely because, oh dear, I need to be hugely competitive and so on. Because I think all of that contributes to your development as a person, and it's that composite identity. And I think the enlightened law firms are looking for that. But I want to encourage you as a generation that rather than viewing things through a gloomy lens or feeling anxious or stressed and strained in an extraordinary way. I mean, there will be natural stress in terms of studying for exams, and I know that's coming up for both of you. So all of that comes with the turf, and don't get me wrong. But what I mean is extraordinary pressures that you might be placing on yourself. I want to encourage you, and I leave this as a parting shot. I want to encourage you to look at this as a moment when you can let your imagination soar, when you can unlock your creativity, when you can do things that you never thought were possible, when you can dream big, when you can let innovation rise, when you can say not why, but why not. This is the moment for ingenuity.
Well, Mr. Vijayendran, thank you. We cannot thank you enough for your insightful opinions into legal industry now and ahead, and at the end, the legal education system as well. I'm sure these views will give those inside and outside the legal industry a food for thought on how the industry can respond to challenges moving ahead and how businesses and individuals may more effectively utilize the situation, the solutions that the legal industry can offer. So on behalf of this project, I want to extend our gratitude to you for being so willing to share your expertise and experience with us and with the larger public. With that, we hope you have enjoyed today's episode. Thank you and stay safe. Thank you very much.
I've enjoyed it very much, and thank you to both of you, Chunman and Thomas, for wonderful facilitation and for intelligent, incisive questions as well that got me to think even before this interview. And once again, a strong note of commendation for the fine work you're doing, and I was very glad that it got profiled by our Straits Times. Thank you.